Let's try this again. Court will call cause number CR 17-39, the state of Texas versus Sean Byford. Mr. Byford, are you with us? Elena, can you hear me?
Yes, sir, I can.
Okay, just making sure. All right, Mr. Byford is not with us on Zoom, nor was he present in the courtroom today.
And also judgment needs to be issued in that case.
Okay, the court would note that the deputy has already called his name 3 times at the courthouse door. We'll grant the relief as requested. Can I have Mr. Zamora's files? Thank you.
Okay. Thank you.
Is Daniel on here? Mr. Rodriguez, you gonna do it in person? Court will call cause number CR 2118, CR 16-122, and 171, the state of Texas versus George Zamora. For purposes of contested motions to proceed in a pretrial, what say the parties?
State's ready.
Your Honor, counsel's not ready to fill on the motion to proceed.
My witnesses.
I probably would have to jump on Zoom to do that.
Okay.
To do the motion.
You want to go to the law library, see if it's
Yes,
set
I
up?
also have a couple of people here.
Who do you have in person? Because I'm showing all the out of custody are done.
Oh, maybe the police.
Second page. Please have a little bit of those.
Mr. Zamora, is that you in the jail? Your client's sitting in the jail right now. Bear with us, Mr. Zamora. We're going to bounce back to you in just a minute, okay? Ms. Robles, do you have a case on the docket today?
For Kennedy Martin,
Judge, it's a witness for a case. We were gonna see if we could do the plea that didn't go through on Friday.
Okay. Okay, thank you. What's your witness's name?
So she said her screening should be Rebecca May, and she's on an iPhone.
Okay, I do have Rebecca May on the screen. Yeah, it looks like Daniel's in the law library. Hey, Ben,
Yes, sir.
you don't have time to talk. Okay.
Yeah.
Sorry, David. We're trying to get a hearing started and we can't until it gets online.
I got a very ruler. I'm not sure they didn't take the note.
They did not take him.
They did not?
No.
Okay.
Yeah, we'll get to him pretty, we'll do him after this.
No problem.
Okay.
No problem. And so the idea that wall library.
Yeah. Yeah.
I'm just going down.
Yeah, you can go sit behind Daniel, make faces. That's-
Judge, may I approach for a second?
You may.
Oh, I'm sorry about that. Hey, Judge, I have to step back into county court here in Bandera for a few minutes. Is my case down the docket for a little bit?
It is. Yeah, just holler at us when you get out.
Okay, I'll log back on this hearing as soon as I'm done there.
Thank you.
Thank you, sir.
Ms. Rose, what hearing are you here for?
Hi, I'm here for Vernon Miller.
Okay. Yeah, if you would just mute yourself and we'll bring you, you'll be able to unmute shortly when they call his case, okay?
Yes, Your Honor. Thank you.
Thank you.
You're welcome, sir.
Ben, can you hear me? Mr. Rosenbach?
Your Honor, there was a, I guess, offer that has just been made by Ben.
Let me
Can I
put
have
you in
two-
the breakout room.
Just for 2 minutes, Your Honor.
What's the identifier on the bottom of the county jail? Okay, thank you.
They're signing into Louis' laptop.
Okay.
So you'll be in the waiting room for you
Thank you.
and you can get the microphone working.
We've had that problem.
Judge, can you hear me now?
I can.
Okay, I can hear you too. Sorry about that. We got it taken care of.
Not a problem. Mr. Rodriguez is meeting with his client in the breakout room and he'll be right back.
Okay.
Well, we're going to do Zamora whenever they come back out of the breakout room. And unfortunately, the allegations are different from one case to the other, so it's going to take a few minutes.
That's all three cases.
Okay, thank you.
Judge,
Yes,
Ben
sir.
and I had spoken right before this. He said he would, he told me what he'd be willing to do. I spoke with my client about what Ben proposed, and we'd like to enter into that plea bargain.
Let's see if we can come back in.
Yeah, he might need help.
Apparently, they signed off.
Uh-oh.
Well, I see Kirk County. Oh, that's Kirk County. Sorry.
Yeah.
They don't see you?
What date do you want to reset for?
Ben, when do you think we can get all the paperwork done? A couple weeks?
Why don't we do it November the 10th? I'd
November
like
the
to, if they can get him back on, I'd like for him to plead true to the motions to proceed. And so that
Okay.
we can,
Well,
That
we
would-
need the paperwork to do that.
oh, we do?
He's in custody, right?
Oh, yeah, he's in custody.
Stay in custody. Bring him to plea day.
Yeah, the soonest plea date or contested date is November the 10th, Dan.
Okay, so it won't be contested anymore. It'll be a plea. Pleas of true, and then a plea, I guess, was it a plea to the new charge or
Yes.
not to the new charge?
To the new-
So pleas of true plus one plea bargain.
Well, we
I can
only
do it
have,
sooner.
okay.
As soon as we can get him back on, what we'll do is reset them all for November 10th.
Okay,
And it'll be reset for a plea, but if he backs out between now and then, it'll be contested.
okay.
And Rebecca, I'll give you a call and let you know what's going on, okay?
Let me go back to the breakout room, see if he's in there.
It could be the last minute. Oh, there you go.
Late afternoon, he calls me.
Okay.
There we go.
We're all here.
Except Mr. Zamora is muted.
Unmute yourself, Mr. Zamora.
There we go. All right, we're back on the record in CR 2118, 16122, and 16171. The state of Texas versus George Zamora. Counsel?
Your Honor, the parties have come to an agreement. We're just requesting that this matter be reset to November the 10th so that we can prepare the paperwork and so that Mr. Zamora can get a sentence on that day.
That's true.
Mr. Zamora, is that your understanding?
Yes, sir.
All right, we will see you back on November 10th at 8:30 a.m. Thank you.
Thank you, Judge. Have a nice day.
Thank you.
Thank you, sir.
There you go. Who would you like to see next?
Vernon Miller, please.
Have a good day, Mr. Emerson.
Thank you, you too.
Go grab my. What do you want? I just didn't bring my. Burning Miller. The police report? Well, the Burning Miller, I need my computer though. You need your computer? I was gonna.
You're just afraid I'd mess your files up. Mr. Black? Are you Mr. Miller?
Yes, sir.
Court will call cause number CR 21-121, 122, and 123. The state of Texas versus Vernon Miller for purposes of a motion to reduce bond. What say the parties?
State's ready?
Defense is ready, Judge.
Mr. Black, the ball's in your court.
Thank you, sir. I'd call my client, Judge, for the limited purpose of reducing his bonds.
Mr. Miller, please raise your right hand. In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you.
All right, Mr. Miller, would you state your name for the court, please?
Vernon Miller.
And how old a man are you, sir?
I'll be 44 this month.
And are you a married man?
Yes, sir.
And how long have you been married?
15 years.
And do you have any children, sir?
Yes, sir.
How many?
4.
All right, and do you live with your wife and children?
Well, at the moment, I live in Banera County.
Yes, sir. When you're not in Banera County Jail.
Yes.
All right, and do you work?
Yes.
And where do you work?
CBW Barbershop.
And that's in San Antonio?
Yes, sir.
And how long have you worked there?
Over 5 years.
All right, and where do you live?
13215 Hillport and 70 Oaks.
And is that in San Antonio?
Yes, sir.
All right. Now, Your bonds are currently set at a total of $50,000. Is that correct?
Yes, sir.
And do you have the financial ability to make those bonds?
Not at 50,000,
How long have you been incarcerated?
84 days.
All right. How much of a bond do you think you could make, total bonds?
If we could go back to the original, that it was from my original case, they went, it was 20,000 and then they went up 10,000 on me. And then they double up on the other ones as well. If we could just go back to the original setting, original bonds would be great.
All right, so that would be when you were magistrated?
I believe so.
All right. And so when you were magistrated, your bonds in the manufacturing delivery case, that was set at a $10,000 surety. The unlawful possession of a firearm was $2,000 surety, and the marijuana case was $2,000 surety. So that was a total of $14,000. Could you make surety bonds on $14,000?
I believe so.
All right. Do you have transportation to get to court when you're supposed to be at court?
Yes, sir.
And would you come to court when you were required to come to court?
Yes, sir.
Is there any other support for your children, for your 4 children, other than your employment?
But my spouse, but 2 incomes is better than 1. I'm sure it's a struggle doing it all by herself.
All right. All right. I'll pass the witness, Judge.
Cross-examination, Your Honor.
May.
Mr. Miller, this isn't your first involvement with the criminal justice system, correct?
What was that, sir?
This isn't your first involvement with the criminal
sir.
justice system,
No,
correct?
sir, but my involvement is so far.
Well, let me just ask the questions and then you can give your answers, please. In fact,
Judge, I would just ask that we limit our questions and answers to the issue of the bond, Judge.
right, and I'm just talking about his previous history. I'm not talking about the guilt.
You may proceed.
And Mr. Miller, in fact, you were convicted. Well, you're originally placed on a deferred adjudication back in March of 2002 for possession of cocaine, a second-degree felony.
Yes, sir.
Is that correct?
Yes, sir.
In Nueces County.
Yes, sir.
And then the court, there was a motion to adjudicate you guilty filed in that case.
Yes, because I had caught a DWI and they want to extend my probation 3 more years. So they offered me 6 months jail time to be done with my probation.
Okay, so you picked up a new case while you're on deferred.
DWI.
Okay, but in fact, the court in the possession of cocaine, they adjudicated you guilty, correct?
I don't understand what adjudicated is, but they gave me 6 months to take care of my probation.
Well, I'm looking at a document that says you got sentenced to 2 years in prison.
Oh, that was the first case, my very, very first case.
Right.
Yeah.
We're talking.
That's
Sorry
because
about-
they gave me SAP. I did SAP and I didn't like 6 months on the street, and then I messed up on my aftercare, and then they gave me 2 years TDC.
We gave you a lot of chances then, huh?
No.
All right. Now, just to, I'm not asking you about that specific information, but just to make sure that you are aware of what you are being charged with currently. Okay, fair enough.
Okay.
And in CR 21121, it's a charge of manufacture, deliver, controlled substance, PG1, cocaine, 4 to 200 grams, enhanced with a prior. You're aware of that charge?
I can't, it's loud over here. Yes, I do. That's about the cocaine charge, right? 42.
Correct.
Yes.
And that charge that we originally talked about had dealt with cocaine, correct?
Yes.
Okay. And then also there's another charge, and just to make sure that you're aware, you've been charged with unlawful possession of a firearm by a felon enhanced, correct?
Yes.
And then also the third case that we're before the court is a possession of marijuana 4 ounces to 5 pounds enhanced, correct?
Yes. I mean, all my charges are enhanced.
Yeah, all your charges are enhanced with your previous conviction. You're aware?
Well, now I am.
Okay. No further questions, Your Honor. Pass the witness.
All right.
Judge, I don't have any further questions of my client. I would like to call Ms. Rose.
I'm sorry, you'd like to call whom?
Katrina Rose.
Ms. Rose, please raise your right hand. In the matter before the court, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. And can you please give your full name to the court reporter?
My full name is Katarina Rose.
And the last name is just R-O-S-E, is that correct?
That's correct. Yes, sir.
Thank you. You can put your hand down. Thank you. Go ahead, Mr. Black.
Thank you, sir. Ms. Rose, would you state your full name for the record, please?
Katarina Rose.
And what's your relationship to Mr. Miller?
We have been very close friends, and I've been with him throughout certain circumstances in his life. I've known him for over 17 years.
Okay. And are you familiar with his current situation in court?
Yes.
All right. Do you have, well, are you in a position to help Mr. Miller, were the judge to see fit to reduce his bond? Are you in a position to help Mr. Miller get to and from court?
I am, yes. And so I can give you a little bit of history about myself. I'm a veteran of the United States Air Force. I'm also a licensed officer, chemical dependent. So I'm sorry, there's somebody else talking. Okay. And I'm currently working in the medical field. So I've always encouraged Mr. Miller to be the best version of himself. So I'm here to be a positive asset in his life and to help him comply with the judicial system. I work for Texas Department of Criminal Justice as a counselor in the prisons as well.
Well, perfect. Okay. Now, do you, based on your experience and knowledge of Mr. Miller, do you believe that he would comply with any bond conditions that the judge would set for him while he was out on bond?
Absolutely. And I feel as a person that's going to assist him with this, that I would highly encourage him and be the individual that would take him.
Okay. All right. You heard his testimony about his financial situation, or is that your understanding of his financial situation?
So yes, we cannot afford the amount of bond that is presented at this time. And so we're asking for a reduction so that we can get on the right track, back to work, and he can start paying his bond, paying all of his fees, and be in compliance as well.
Right. Now, has the district attorney brought up some of his, all of his criminal history? Were you aware of that?
I have been aware, and I believe that it's redundant because it's been over a decade. And so at this point in time, people make mistakes. Mr. Miller was overwhelmed by situations and circumstances that were happening in his personal life at the time. He was going through a divorce, the sickness of his mother. And so at the time, he was not considering all of his actions as being detrimental to his future because he was unstable, emotionally unstable. So I believe currently that with counseling and therapy, with dealing with his depression, dealing with all of life circumstances that he's been facing, that he can overcome this and he can be the best version of himself.
And are you willing to help him do that?
Absolutely. So I have quite a few ties in counseling and therapy. I've been in the medical field for over 2 decades. So absolutely, yes. I do believe that. I believe 100% that despite the mistakes that we've made in our past, we're not victims of our past mistakes. We're advocates for our future successes.
Great. And have you had occasion to visit with Vernon from time to time since he's been incarcerated?
I have not, but we talk every day. We write letters. I've sent him motivational books, and I've encouraged him to keep his head up high. And, you know, it's been very difficult for him and I because we've been going through transitions. I've been working, so I've been unable to go in person.
Okay, but you have visited with him on the telephone?
Absolutely, every day.
All right. So do you believe, based on those visits, that Vernon is ready to make the change that he needs to make?
I do. And he's been incarcerated long enough to have a clear mindset. Typically, it takes 90 days, 60 to 90 days for someone who's been under the influence of drugs or alcohol to get clarity of mind. And he's definitely received clarity of mind. He understands that he's made huge mistakes, and he's remorseful about it. He wants to better himself. He wants to come out here and start working and start his barber school and start being the best version of himself. I do believe that.
Yeah, great. I'll pass the witness, Judge.
Just very briefly, Your Honor. Good morning, Ms. Rose.
Morning.
Just to be clear on the record, what is your relationship with Mr. Miller?
So we're friends, personal friends.
And how did you meet him?
I met him when I was active duty Air Force.
And how long have you been friends with Mr. Miller?
So it's been over 17 years.
So when you met him, you were already aware that he was a convicted felon?
I didn't ask personal questions like that. And to me, you know, someone's history is.
Well, I'm just asking if you knew or not, but you know now, right?
Mm-hmm.
And then you said you've been in contact with him every day in jail.
That's correct.
On the phone.
Mm-hmm.
Has he made any admissions possessing cocaine while y'all been on the phone?
Objection, Your Honor. That's not relevant to the bond issue.
Well, she brought up in her direct testimony that he's made mistakes and he was on drugs and 90 days to clear himself up. So I think she made it relevant.
I can answer that. I was talking in lieu of counseling and therapy and what typically happens with a client that may be under the influence of drugs or alcohol. Now, as far as him indicating to me that he was on drugs, he did not, and that was not an issue at all.
Okay. So if we review the jail calls, because y'all are friends, you're not his counselor, correct?
That's correct.
If we review those phone calls, there won't be any admissions from Mr. Miller to you about possession of cocaine or anything like that?
That's correct.
All right. No further questions, Your Honor.
Mr. Black?
Judge, that's all I have.
All right. Thank you, Ms. Rose.
Thank you, Your Honor. Have a great day.
Thank you, you too. Any additional witnesses, Mr. Black?
No, sir. No, sir. That's all the witnesses I have.
State?
No witnesses, Your Honor, just argument.
Okay. May proceed, Mr. Black.
Thank you, Judge. I think very succinctly, I think that my client has shown that he does have ties to the community, that he's not going to be a flight risk, and he's going to be around to answer to these charges. And he's also shown a desire to improve himself. So we respectfully ask that you reduce these bonds.
Mr. Rosenbach?
Briefly, Your Honor, I disagree with Mr. Black. I think that Mr. Miller has shown that he has been involved in the criminal justice system. He can't abide by those community supervision things to the point where he had to go be sentenced to prison. The original case involved cocaine. The case that's alleged now involves cocaine. And I think that the bonds that are set right now are reasonable, and we think that they should remain as they are.
Thank you. Anything else, Mr. Black?
No, sir.
Court's going to deny the motions to reduce bonds. When's our next pretrial?
I believe November 15th, Your Honor.
I believe that's correct, Judge.
All right, Mr. Miller, we'll see you November 15th. If you're out on bond, it's at 8:30 in the morning. And if you're not, we'll see you in the afternoon. Thank you, sir.
Thank you.
One more piece of scotch tape. The piece of scotch tape. Thank you. See if I can move everything away from it so you don't throw things at me. Okay. Can I get your name, sir?
Martin Smith.
Thank you. Mr. Parrott is still in county court, so we're going to have to bring you back in just a few minutes, Mr. Smith. As soon as your attorney gets through in the other court. So if we can jump to, if you can hear me in the jail, if we can jump to Don Waterman.
Yes, sir.
Thank you. Thank you. Thank you. Mr. Parent, if you'd been 30 seconds earlier, you would have caught your client. So we're going to have to call him back in just a few minutes.
Nah, no worries. I got another about 10-minute break so I can hang loose.
Paul, you ready? Court will call cause number CR 2141, the state of Texas versus Don Waterman. For purposes of an agreed plea, what say the parties?
State's ready.
Defense is ready, Your Honor.
First document we need to go through is the joint request for plea or sentencing by video conference. Purports to be signed by all the parties. Ms. Waterman, do you have any objection to proceeding today by video conference?
No, sir.
Thank you. Next document we need to go through is the 3914 Discovery Disclosure and Compliance Form, which purports to have each of your signatures. Is that correct?
Yes, sir.
Mr. Rosenbach,
Yes, Your Honor. I'm sorry.
to the best of your knowledge, has the state received all discovery from law enforcement and forwarded the same to the defense?
Yes, Your Honor.
To the best of your knowledge, have you received all discovery?
Yes, Your Honor.
Thank you. Ms. Waterman, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments.
Yes, sir.
Did you have a chance to go through that document with your attorney?
Yes, sir, I did yesterday.
Did you understand that document?
Yes, sir.
Do you understand that you have a right to a trial by jury?
Yes, sir.
Do you understand that you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of this document purports to have your signature in 2 locations.
Yes.
Is that your signature in both spots?
Yes, sir, it is.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
Yes, sir.
Attached to the back of this document is a copy of the grand jury indictment. Did you have a chance to go through that indictment with your attorney?
Yes, sir.
Did you understand that indictment?
Yes, sir, I did.
And are you asking the court to accept that indictment as true and correct?
Yes, sir.
Do you feel like your client understands her rights, waivers, and admonishments?
I do, Your Honor.
Ms. Waterman, you've been charged with theft of a firearm. This is a state jail felony with a range of punishment of 6 months to 2 years confinement and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir, I do.
And how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir, I am.
Do you feel like your client's competent and capable of assisting you in preparation for trial, Ms. Daly?
Yes, Your Honor, I do.
Is there a plea agreement?
Yes, Your Honor. In 21041, 5 years deferred adjudication probation, $500 fine, drug or alcohol treatment approved by the probation department, and the life skills course. And then as part of our plea bargaining agreement, the state's tendering a motion to dismiss CR 21-175. It was a failure to appear.
Is that your understanding, Ms. Daly?
It is, Your Honor.
Is that your understanding, Ms. Waterman?
Yes, sir.
Okay, let's talk about deferred adjudication briefly. Do you understand that deferred adjudication is like a two-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure.
Yes, sir.
Okay, do you understand the flip side of the coin? If you violate your terms and conditions of probation, you're subject to the full range of punishment for the offense.
Yes, sir.
In addition to that, do you understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, you would have the opportunity to withdraw your plea of guilty, enter a plea of not guilty, and proceed to trial. And are you asking the court to follow the plea agreement?
Yes, sir.
Court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 5 years. You have a fine in the amount of $500. You must successfully complete a drug and alcohol treatment program if ordered to do so by probation. You must successfully complete the life skills program. You have court costs in the amount of $290 and reimbursement fees in the amount of $690. Do you have any questions on the judgment itself?
No, sir.
Once you get released, can you work out a payment plan to pay off your cost?
Yes, sir.
Attached to the back of the judgment is the order granting community supervision. Did you have a chance to go through that document with your attorney?
Yes, sir, I did.
Do you understand that that order contains all your terms and conditions of probation?
Yes, sir.
Do you understand your terms and conditions of probation include a $60 per month probation fee?
Yes, sir.
a one-time $50 Crime Stoppers fee?
Yes, sir.
Do you understand you're subject to random urinalysis and drug test at your own expense?
Yes, sir.
Do you understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete the life skills program?
Yes, sir.
Where do you work?
I don't right now. I was doing home health care, so I get a disaster relief pay.
Is that what you're planning to go back into?
Yes, sir.
As a term and condition of probation, you have 150 hours of community service. Work with your probation officer so they can work around your job.
Yes, sir.
Your Honor, if I may, really quickly, we would ask that those community service hours be held in abeyance. She does have a medical condition called spherocytosis. It's a extreme immune compromising condition, and she's concerned about having to do community service around other people. If we can't hold it in abeyance, we would ask that she be allowed to make donations to count as her community service hours.
You have two choices. You can either present some kind of medical document showing that it's not safe for you to be around other folks, or you can pursue it through the donation route, but work with your probation officer, okay?
Yes, sir. Thank you very much.
Thank you, Your Honor.
Do you have any other questions?
No, sir.
All right, thank you, Ms. Waterman.
Thank you.
Judge, if I may,
Yes,
ma'am, please report to probation when you get released, okay?
Yes, ma'am. I assume you'll tell me where that is.
It's are you in Bandera County Jail?
Yes, ma'am.
Okay, it's right in the front of the Justice Center in the middle.
Okay.
Yes, ma'am.
Thank you.
Thank
Do I need to
you.
speak to somebody specific or just go in there?
Just go in there. They'll help you get an intake appointment set up.
Thank you very much.
You're welcome.
215. Okay, thank you, ma'am. And if you can hear me in the Bandera County Jail, if we can get Mr. Smith back, that would be wonderful.
Yes, sir.
Your Honor, may I be excused?
You may. Thank you very much.
Thank you. And would you like me to log out in the law library or keep it up?
Go ahead and keep it up.
Okay, thank you, Your Honor. Have a good
Thank
day.
you. You too. Right. Court will call cause number CR 18-215, the state of Texas versus Martin Smith. For purposes of an agreed plea, what say the parties?
Date's ready.
Defense is ready.
First document we need to go through is the joint request for plea or sentencing by video conference. It purports to have each of the parties' signatures. Mr. Smith, do you have any objection to proceeding today by video conference?
No, sir.
Thank you. First document we need to go through is defendant's plea of true to state's motion to revoke. Did you have an opportunity to go through that document with your attorney?
Yes, sir.
Did you understand that document?
Yes, sir.
Do you understand that you have the right to have a contested hearing before the court today?
Yes, sir.
And do you understand you have the right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand that you're waiving those rights?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
At the bottom of page 1, it purports to have your signature. Is that your signature?
Yes.
Do you understand that by signing the bottom of page 1 with the stipulation of evidence paragraph right above your signature, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing.
Yes.
Do you feel like your client understands his rights, waivers, and admonishments?
Yes, sir, I do.
Mr. Smith, I'm showing you a 3-page document marked as State's Exhibit A. Contains all the allegations that were made against you in the state's motion to revoke. Did you have a chance to go through this document with your attorney?
Yes, sir.
Did you understand that document?
Yes.
Do you understand each individual allegation?
Yes, sir.
And to those individual allegations, are you pleading true or not true?
Yes, sir. True.
And that's on both count 1 and count 2?
Yes, sir.
Are you pleading true freely and voluntarily?
Yes, sir.
Are you pleading true because they are true?
Yes.
Are there plea agreements?
Yes, Your Honor. 2 years confinement TDCJID. Oh, I'm sorry. 2 years confinement TDCJID. All balances of fines and fees are still due. And then he has jail time credit as reflected on the judgment. I believe that's very close to, if not already, a time served. Is that correct, Mr. Parent? Or?
I believe that's correct. I don't have the judgment in front of me, but I think that's correct.
Is that your understanding of the plea agreements, Mr. Smith?
Yes, sir.
And are you asking the court to follow those plea agreements?
Yes, sir.
On both count 1 and count 2, the court will find sufficient evidence to enter a finding of true the state's motion to revoke. On both count 1 and count 2, will revoke your probation, order you confined in the Texas Department of Criminal Justice for a period of 2 years. All balances of fines and fees previously ordered are still due. It looks like in count 1, you still have a fine in the amount of $1,500. You still have court cost in the amount of $453. And you have reimbursements fees still owing in the amount of $1,577.50. You have time credit, looks like from February 4th of 2019 through June 7th of 2019, and then July 25th of 21 to present. Do you have any questions at all on either one of these judgments?
No, sir.
Okay, at some point today, you're going to see somebody come over there with one of your judgments. It looks like they got your thumbprint on one, but not the other. So they're going to ask you to put your thumbprint on count 1, please.
Okay.
You have any questions at all?
No, sir. Well, I'm wondering about the time served, you just said?
Yeah, you'll get time served for all that time that I read you, those dates that I read you that's on the front of the judgment.
Okay.
And if for some reason you don't think that's right, then let your attorney know and we'll go back and try to research it. You have any other questions?
No, sir.
All right. Good luck to you, Mr. Smith.
Good luck to you.
Thank you. Go, Dave.
And Judge, that's all I have. May I be excused?
You may. Thank you, David.
Thank you very much. Talk to you soon.
You may, David. Thank you.
We had Sean Blackford in custody. Do you want to see him still?
I'm sorry, who do you have?
Sean Byford. He was the first one you called. We have him in our custody.
Oh,
Have him fill out an app. We did an FTA on him, didn't we?
yeah, that's correct, Your Honor.
Okay, and he's in custody in the Banera County Jail?
Yes, sir.
Okay. The court will call cause number CR 17-39, the state of Texas versus Sean Byford. The first thing we need to address is that earlier the court had issued a warrant in ISI for failure to appear. It's come to the court's attention that Mr. Byford is present in the Banera County Jail, so the warrant in the NISI will be withdrawn by the court. If you can hear me in the jail, Mr. Byford, I'm not showing an attorney. He needs to fill out an application for court-appointed counsel if he's going to request counsel, and if not, then he needs to hire his own. And what we're going to do is reset him for November 10th at 10 a.m.
Yes, sir.
Okay.
All right.
Thank you.
Yes, sir.
Is that? Mr. Braun or Mr. Martin? If you can hear me in Kirk County, if you want to go ahead and pull Mr. Martin, he'll be right after the next guy, Mr. Bronner. And you're muted.
He's ready to go.
Okay. Thank you.
You're welcome.
Bronner's attorney. Yeah, hold off on well here. Just taking the paperwork and telling him I need something on the first paragraph checked off. On the admonishments. Yeah, he needs to tell me one way or the other. If you want to go ahead and pull Mr. Martin.
Yes, sir.
Thank you. So, Mr. Zinner, we need to mask up, please. Are you Mr. Martin?
Yes, sir.
Okay. Court will call cause number B20-555, the state of Texas versus Kennedy Martin. For purposes of an agreed plea, let's say the parties.
Fence is ready.
First document we need to go through, counsel, is the joint request for plea by video conference. It purports to have each party's signature. Mr. Martin, do you have any objection to proceeding today by video conference?
No, sir.
Thank you. Mr. Martin, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments. Did you have a chance to go through that document with your attorney?
Yes, Your Honor.
Did you understand that document?
Yes, Your Honor.
You understand that you have a right to a trial by jury?
Yes, Your Honor.
You understand that you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And you understand you have a right to appeal?
Yes, Your Honor.
You understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, you understand that you have a right to remain silent. Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, Your Honor.
Page 3 of this document purports to have your signature in two different locations. Is that your signature in both spots?
Yes, Your Honor.
Your second signature appears underneath the paragraph entitled Judicial Confessions and Stipulations. You understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing.
Yes, Your Honor.
Attached to the back of this document is a copy of the grand jury indictment. Purports to have your signature at the bottom. Is that your signature?
Yes, Your Honor.
And are you asking the court to accept this grand jury indictment as true and correct?
Yes, Your Honor.
Do you feel like your client understands his rights, waivers, and admonishments?
I do, Your Honor.
We're going to backtrack just a hair to the 3914 Discovery, Disclosure, and Compliance form, which purports to have each of your signatures. Is that correct?
Yes, Your
That's
Honor.
correct, Your Honor.
Correct, Your Honor.
To the best of your knowledge, has the state received all discovery from law enforcement and forwarded the same to the defense?
Yes, Your Honor.
To the best of your knowledge, have you received all discovery?
Yes, Your Honor.
Thank you. Mr. Martin, you've been charged with assault of a pregnant person. This is a third-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, Your Honor.
And how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
And are you a citizen of the United States?
Yes, Your Honor.
Do you feel like your client's competent and capable of assisting you in preparation for trial?
I do, Your Honor.
Is there a plea agreement?
There is, Your Honor, but we might want Ben.
Yes, there is, Your Honor. I just don't. Yes, Your Honor, there's a plea agreement. In this case, it's 5 years deferred adjudication probation, $1,500 fine, bit class, the LTIP, drug alcohol treatment approved by the probation department, and supervised contact only with regard to parental visitation.
Ms. McCollum, is that your understanding of the plea agreement?
It is, Your Honor, with the addition of there was a motion to dismiss another cause number for my client, which was a FTA. And then as far as the supervised contact only, we do have a witness and we would like that stricken from the judgment if possible.
Was that part of your plea agreement?
Stephen did ask me to have a witness here. I don't know that they're opposing it or pro, but
I believe that was part of the plea agreement, Lauren. So it's not
Okay.
necessary. I mean,
We'll bounce back to it in just a moment. Mr. Martin, is that your understanding of the plea agreement?
Yes, Your Honor.
Okay, let's talk about deferred adjudication. Do you understand deferred adjudication is like a two-sided coin? If you successfully complete all your terms and conditions of probation, not only do you not have a final judgment, but you may be entitled to file a motion for non-disclosure.
Yes, Your Honor.
Okay, do you understand the flip side of the coin? If you violate your terms and conditions of probation, you're subject to the full range of punishment for the offense.
Yes, Your Honor.
In addition to that, do you understand that a plea agreement's an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, you would have the opportunity to withdraw your plea of guilty, enter a plea of not guilty, and proceed to trial.
Yes, Your Honor.
And are you asking the court to follow this plea agreement?
Yes, Your Honor.
Ms. McCollum, do you want to address the supervised contact before we get into that?
Yes, Your Honor. If I may, I would like to call Nicole Robles as a witness.
Ms. Robles, please raise your right hand. In the matter before the court, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And can you please give your full name to the court reporter?
Nicole Robles.
Thank you. You may proceed.
Thank you, Your Honor. Ms. Robles, how do you know Kennedy Martin?
We've been together for 2 years.
When you say together, you're romantically involved?
Yes,
And where does Kennedy live?
he lives with me.
And how many children does he have?
We have one together and I have 4 total that he's raised 2 of them.
So he has one biological child in the home,
Yes,
but there's 4 total in the home?
yes,
And is he help you with parenting responsibilities?
yes. He helps me a lot.
Has CPS ever been involved with your family or any of your children?
No,
Are you wanting Kennedy to continue living with you and helping with the children?
yes. He helps me a lot with my kids, my 2 older ones, with getting them to school every day and picking them up. I have medical issues, so I am not like fully be able to do it by myself. It's been a struggle since he's been in there right now.
Do you feel that there should be any restrictions on his contact with the children?
No,
And you mentioned medical issues. Can you tell us briefly what some of those are?
I have to have a DNA done to go back in and basically fix the bleeding issue I have from having RSA. And I've had to postpone it because he's in jail because I need time to recover afterwards. And so I have to get that done like ASAP.
So is it fair to say today you would request and ask the judge that Kennedy be allowed full contact with the children and be allowed to live in the same home with you and the children?
Yeah.
I'm sorry, I think you're cutting out a little bit. Can you repeat your answer to that?
Yes, I am.
Pass the witness, Your Honor.
Ms. Robles, you are the victim in this case?
Yes, I was.
Okay, and you understand that he's going to be on community supervision with a lot of rules and regulations on him, correct?
Yes, I am.
Okay, and in fact, if he were to violate any of those conditions, he might be sent to prison.
Yes, I am.
Okay, and we would just request that you would, if there are any things that go wrong, please let law enforcement know. Because you understand you are taking a risk by asking the court for him to come back and live with you, correct?
Yes.
But you're well aware of all those risks and you want to take those on. Okay. Fair enough. Pass the witness.
No further questions from me, Your Honor.
Court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 5 years. You have a fine in the amount of $1,500. You must successfully complete the Betters Intervention and Prevention Program, the Life Training Institute Program, If ordered by probation, you must successfully complete a drug and alcohol treatment program. You have court costs in the amount of $290. You have reimbursement fees in the amount of $510. Do you have any questions on the judgment itself?
No, Your Honor.
Attached to the back of the judgment is an order granting community supervision. Did you have an opportunity to go through that order with your attorney?
Yes, Your Honor.
Did you understand that order?
Yes, Your Honor.
You understand that order contains all your terms and conditions of probation?
Yes, Your Honor.
Do you understand your terms and conditions of probation include a $60 per month probation fee,
Yes, Your Honor.
a one-time $50 Crime Stoppers fee?
Yes, Your Honor.
Do you understand you're subject to random urinalysis and drug tests at your own expense?
Yes, Your Honor.
Do you understand you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, Your Honor.
Do you understand you must successfully complete the Life Training Institute program?
Yes, Your Honor.
Do you understand you must successfully complete the Batterers Intervention and Prevention program?
Yes, Your Honor.
Where do you work?
Right now I do landscaping, kind of like self-contract.
Think you'd be able to jump right back into that?
Yes, yes, Your Honor.
Good. As a term and condition of probation, you have 150 hours of community service. Work with the probation department so they can work around your employment schedule, okay?
Yes, Your Honor.
All right, do you have any questions at all?
No, no, Your Honor.
Okay, as soon as you get released, go across the parking lot and report to probation, please.
Yes, sir.
Thank you, Mr. Martin.
Thank you.
Thank you, Your Honor. May my witness be excused and may I be excused?
Yes and yes.
Thank you. Thanks for doing the plea today. Appreciate it.
Welcome.
Thanks, Ben. And thank you, Karen.
Bye, Lauren. See you later.
All right, now, unfortunately, I think we lost Banera County Jail. They signed off for some reason. Yeah. And we need Bronner.
Isn't Mr. Bronner out?
Oh, I'm sorry. He's out in front of me. Never mind.
Okay, I'll be out there. Hold on a second.
Yeah, he's out of custody. Never mind. Excuse me. Mr. Bronner, come on down. How are you? Good. Court will call cause number CR 20-77 and 21-120. State of Texas versus Robert Bronner for purposes of agreed pleas. What say the parties?
State's ready. We're ready to go.
First documents we need to go through in each case, counsel, are the 3914 discovery, disclosure, and compliance forms, each of which purports to have each of your signatures. Is that correct?
Yes, correct. That's correct.
To the best of your knowledge, has the state received all the discovery in both cases, reported the same to the defense?
Yes, Your Honor.
To the best of your knowledge, have you received all discovery in both cases? Paragraph 1. I need paragraph 1 marked, please. Thank you. Any objection to going through the admonishments together?
No objection.
Mr. Bronner, I'm showing you one document, but in fact, there's two. It's entitled Defendant's Plea of Guilt, Waivers, and Admonishments. Did you have an opportunity to go through both of these documents with your attorney?
Yes, sir.
Did you understand both documents? Do you understand in each case you have a right to a trial by jury? Do you understand in each case you have the right for your attorney to cross-examine the state's witnesses and to call your own witnesses? And do you understand in each case you have a right to appeal? Do you understand that you're waiving all three of those rights in both cases today? In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right. And do I need to move your microphone? Okay. Page 3 of each of these documents purports to have your signature in 2 locations on each document. Do you recall signing both documents twice on page 3? Your second signature on each one appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing this paragraph on each of these documents, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing. Attached to the back of both of these documents is a copy of the grand jury indictment for each case. Did you have a chance to go through both indictments with your attorney? Did you understand both indictments? And are you asking the court to accept as true and correct both grand jury indictments? Do you feel like your client understands his rights, waivers, and admonishments in both cases?
Yes, Your Honor.
In CR 20-77, you've been charged with forgery of a government document. This is a 3rd-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment? Bless you. And how do you plead? Cause number CR 21-120, you've been charged with assault, family violence, impeding breathing. This is also a 3rd-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment? And how do you plead? Are you pleading guilty freely and voluntarily? Are you pleading guilty because you are guilty and for no other reason? And are you a citizen of the United States? 1 second. In each of these cases, do you feel like your client's competent and capable of assisting you in preparation for trial?
Yes, Your Honor.
Are there plea agreements in both cases?
Yes, Your Honor. 20077, 3 years of adjudication probation, $2,500 fine. Drug or alcohol treatment probation department, LTIP class, no early termination probation. And the same in 21-120, except there's no fine. There is a bid class and no contact with the victim in the case.
So that's your understanding of both plea agreements?
Yes, Your Honor, and just so the court knows that the victim and the defendant have children together. And at some point, I think they're gonna have to work out how the visitation.
There's ways to work around that without you having contact. Okay. Is that your understanding of both plea agreements? Let's talk about deferred adjudication briefly. Do you understand that deferred adjudication is like a 2-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure. You understand that? Do you understand the flip side of the coin? If you violate the terms and conditions of probation on either one of these cases, you're subject to the full range of punishment. Do you understand that? In addition to that, do you understand that a plea agreement's an agreement between you and the state? It's not binding on the court, but if the court did not accept either one of your plea agreements, you would have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial. And are you asking the court to follow both plea agreements? CR 2077 and CR 21-120, the court will find evidence beyond a reasonable doubt to enter a finding of guilt in both cases. In each of those cases, we'll defer any such finding of guilt for a period of 3 years. In the 77 case, you have a fine in the amount of $2,500. In both your cases, you must successfully complete a drug and alcohol treatment program if ordered to do so by probation. You must successfully complete the Life Training Institute program. The state's not agreeing to any early termination. You must successfully complete the Batterers Intervention and Prevention program. And do you understand that you can't have any direct contact with the victim? Okay. What that's going to mean on whatever your suit affecting parent-child relationship case is with your children is you're going to have to set up like electronic communication through My Family Wizard or one of those. Okay. And then you can coordinate your visitations and pickups and exchanges and so forth for the kids. Okay. Each of your cases has court cost in the amount of $290. The 77 case has reimbursement fees in the amount of $165. And the other case has reimbursement fees in the amount of $90. Do you have any questions on either one of these judgments? Attached to the back of both judgments is an order granting community supervision. Did you have a chance to go through these orders with your attorney? Did you understand these orders? Do you understand these orders contain all your terms and conditions of probation? Do you understand your terms and conditions of probation include a $60 per month probation fee? There's 2 cases, but there's only 1 fee, okay? Do you understand that each case carries a one-time $50 Crime Stoppers fee that's due within 6 months? Do you understand that you're subject to random urinalysis and drug test at your own expense? Do you understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation? Do you understand that you must successfully complete the Batterers Intervention and Prevention program? You must successfully complete the Life Training Institute program. You understand that you cannot have any direct contact with the victim. And you understand that the state is not agreeing to any early termination. Where do you work? I'm sorry. Staying busy?
Always got work, always got something to do. That's busy enough.
Okay. I'm going to put all your community service in one case so you're not bouncing back and forth. In the CR 21-120, you're going to have 175 hours of community service. Work with your probation officers so they can work around your class requirements and your job requirements, okay? Do you have any questions at all on your terms and conditions of probation? Get some signatures on there. Thank you. Any questions at all? All right, good luck to you. Thank you. Thank you. Absolutely. Thank you. All right, Zinner. Or Mr. Banera. Oh, there he is. Thanks. Thank you. Court will call cause number CR 17-106, the state of Texas versus Glenn Zentner. That's been said. How are you, sir? Good. For purposes of a motion to revoke, what say the parties?
Please, sir. Judge, I am not ready. Don't need much time to get ready, but more important for the state. And my client used to live here. He moved to Fort Worth. I did not have contact with him up to today. I do have all the information for the court that should be in your file regarding his failure to appear. Doctors, hospital.
I'm sure we have it because the court, the docket entry noticed that I withdrew the warrant.
Yes, sir. Oh, that's right, that's right. And of course, he got a recess for today. So I guess my question for the court is would you give me an opportunity to A, confer with the state, and two, if necessary, set this for an evidentiary hearing?
Short answer to that is yes. But that being said, Mr. Zentner, can you give me a good mailing address? Because everything keeps bouncing back.
Yes, sir. 1001 North Border Street.
Border?
Yes, sir. Cleveland, Texas.
Court's going to reset this case for November 10th at 10 a.m. Be sure you stay in touch with Mr. Pereira because he can't help you prepare if you don't stay in touch with him. Okay, we will see you back in person November 10th at 10 a.m. Thank you. Welcome. Okay. I think that's a wrap as far as I can tell. You what? We don't have any other attorneys.